Everyone thought she had lost her mind. A woman walks into a courtroom and sues her billionaire employer for exactly $1. Not a typo, not a placeholder. $1, written clearly on the claim form in handwriting that did not waver. Her attorney, because she did have an attorney, a young one, working for almost nothing, tried to talk her out of it twice before the hearing. The defendant's legal team laughed when they read the filing. One of them actually said, in the hallway outside my courtroom, loud enough for my clerk to hear, "This is either a publicity stunt or she doesn't understand how lawsuits work." She understood exactly how lawsuits work. By the time I finished reading my ruling that morning, the gallery was on its feet, not clapping. Courtrooms don't clap, I don't allow it, but standing, spontaneously, people who had come for entirely different cases, sitting in the back rows waiting for their own names to be called, rising out of their seats because something had just happened that demanded more than sitting still. I have been on this bench for 40 years. I have never seen a courtroom do that for $1. Stay with me, because the reason behind that dollar is the most carefully constructed piece of moral architecture I have encountered in this courtroom in a very long time. And the woman who built it is not who you think she is. Her name was Margaret Chen. She was 44 years old. She had worked for 11 years as the head of quality control at a pharmaceutical manufacturing company owned by a man named Victor Sandoval, whose net worth, according to the most recent business publication ranking, sat somewhere north of $2 billion. Margaret's job for 11 years had been simple to describe and difficult to execute. Make sure the medication leaving that factory was exactly what it claimed to be. Right dosage, right purity, right packaging, no shortcuts. 8 months before this hearing, she had found a shortcut. A batch of blood pressure medication, 600,000 units, had failed an internal purity test by a margin that Margaret described in her testimony as small but real, small enough that a reasonable person could argue it fell within acceptable variance, real enough that Margaret's training told her something was wrong with the manufacturing process upstream, and that ignoring it once meant ignoring it forever. She had flagged the batch for destruction. Her direct supervisor had overruled her. She had gone over his head to a vice president. The batch shipped anyway. Margaret Chen had spent the following 6 months documenting everything, every email, every meeting, every internal memo where she raised the purity concern and was told in increasingly direct language to let it go. She built a file that eventually ran to over 400 pages. And then she did something that I want you to sit with for a moment, because what she did next is the entire reason this case ended up in my courtroom. She did not go to the press. She did not go to a competitor. She did not sell the information to anyone, though I would later learn she had received 3 offers to do exactly that, for sums of money that would have changed her life. She filed a wrongful termination and whistleblower retaliation claim because the company had fired her 2 weeks after the shipment on pretextual grounds that her 400 pages dismantled without difficulty, and she asked for $1. I called the case at 9:30. Margaret arrived with her attorney, a young man named David Osei, who had taken the case, I would learn, because the larger firms had declined it, not because the evidence was weak, but because suing a man with Victor Sandoval's resources over a claim worth, on its face, almost nothing, was not a profitable use of a law firm's time. Margaret sat at the plaintiff's table with a single banker's box. Inside it, 412 pages, tabbed, dated, organized with the same precision she had presumably brought to 11 years of quality control work. Victor Sandoval did not appear personally. He sent 3 attorneys from one of the most expensive litigation firms in the state, led by a senior partner named Richard Voss, who opened the hearing by noting, with the faint amusement of a man who has already calculated that he cannot lose anything that matters, that the plaintiff's claimed damages were $1, and that his client was prepared to simply pay it immediately to resolve the matter without further proceedings. I looked at him for a moment. I said, "Counselor, your client is welcome to pay the dollar, but Ms. Chen has requested a finding on the merits, a formal judicial determination of wrongful termination and whistleblower retaliation. That finding does not disappear because the financial remedy is small. We are going to proceed with the hearing." Voss's expression did not change much, but something underneath it did. Margaret presented her case herself, with David Osei guiding the structure, but Margaret doing most of the talking. She walked through the failed purity test. She walked through the chain of internal communications. And this is where I need to tell you something, because what came out over the next 40 minutes was not what anyone in that room expected, including, I suspect, Victor Sandoval's own attorneys. The emails did not just show Margaret being overruled. They showed exactly when the company had learned about a prior incident 18 months earlier, before Margaret had even joined the quality control team in her current capacity, involving a different batch, a different drug, and 3 documented adverse patient reactions that had been quietly settled with non-disclosure agreements before any regulatory body had been notified. Margaret had not known about that prior incident when she filed the purity flag. She had stumbled into it during her own investigation while building her case file, when an older employee mentioned it to her in passing, and she had pulled the records to understand what she was dealing with. I need you to stop with me right here, because what was buried in page 291 of Margaret's 400-page file was not just evidence that she had been wrongfully retaliated against. It was evidence of something the company had been hiding for a year and a half. And the lawyers across the room, Richard Voss and his 2 colleagues, had no idea it was coming until Margaret read the page number out loud. I watched Richard Voss's face when Margaret reached page 291. He had been sitting with the composed stillness of a man who has read every page of opposing counsel's exhibit list and knows precisely what is coming. That stillness changed. Not dramatically. He was too experienced for drama. But his hand, which had been resting flat on his notepad, closed slightly. A small, involuntary tightening. He had not known. I asked Margaret to continue. She described the prior incident in the same measured voice she had used for everything else. 18 months earlier, a different medication. 3 patients hospitalized with adverse reactions traced back to a manufacturing inconsistency that internal documents she had pulled from the archive specifically because an older colleague named Harriet Voss, no relation to the attorney, had mentioned it to her over coffee one afternoon, showed the company had identified, understood, and resolved through settlement rather than disclosure. No FDA notification, no public recall, 3 settlements, 3 non-disclosure agreements, and a batch that had already shipped before anyone caught the problem. Margaret had not been part of that. She wanted to be clear about that, and she said so explicitly. She had only learned about it 8 months ago, during her own investigation into her own retaliation case, and she had included it in her file because she believed the court needed the full context of the company's pattern of behavior, not to inflate her own claim, but because she believed, and said so directly, that someone in this room needed to know. I looked at the 3 attorneys. David Osei, beside Margaret, had the careful stillness of someone who had known this evidence existed and had decided strategically to let his client deliver it in her own words rather than through legal argument. It landed harder that way. He knew it would. Richard Voss requested a brief recess to consult with his client. I granted it. When we returned, His posture had changed completely. The faint amusement from the opening of the hearing was gone entirely. He said, "Your Honor, my client would like to address the court directly, if permitted." I had not expected that. Victor Sandoval had not appeared that morning. I had assumed he would not. I said, "Is your client present?" He said, "He is in the building. He arrived during the recess." I want you to imagine what it took for a man worth over $2 billion to be sitting somewhere in that courthouse, unannounced, listening to his own attorneys realize in real time that a former employee's $1 lawsuit had just exposed something he had spent 18 months and an unknown amount of money making sure no one ever found. I said, "Bring him in." Victor Sandoval entered my courtroom 15 minutes later. He was 61 years old, dressed simply, and he did not have the bearing of a man arriving to perform contrition for an audience. He had the bearing of a man who had just been told by his own counsel exactly how much trouble he was in and had decided that managing it himself was the only remaining option. He approached the front of the courtroom. He did not sit at the defense table. He stood. He said, "Your Honor, I would like to speak to Ms. Chen directly, if the court permits it." I looked at Margaret. I looked at David Osei. I said, "Ms. Chen, do you consent to this?" Margaret said, "Yes, Your Honor." Victor Sandoval turned to face her. He said, "I did not know about the purity flag until this morning when my attorneys called me during the recess. I want to be honest with this court. I am not certain whether that is something I should be proud of or ashamed of. A company of our size should not require its CEO to personally review every quality control flag for me to know my employees are being retaliated against for doing their jobs correctly." He said, "I did know about the incident 18 months ago. I made the decision to settle rather than disclose. I made that decision because I was told by people I trusted that disclosure would damage the company more than the actual risk to patients justified. I believed them. I should not have believed them without verifying it myself." He said, "Ms. Chen, you found something that I paid a great deal of money to make sure no one found. And instead of selling it, instead of going to a journalist, instead of doing what I am certain would have been more profitable for you personally, you brought it to a courtroom and asked for $1. He paused. He said, "I would like to understand why." Margaret Chen looked at him for a long moment. She said, "Because $1 is enough to win. And winning was never the part that mattered to me." She said, "I didn't want your money, Mr. Sandoval. If I take a settlement, this becomes private. It becomes a number in a confidential agreement that nobody ever hears about. The same way your 3 patients 18 months ago became 3 confidential agreements that nobody ever heard about. I have watched how that works. I did not want to become another one of those numbers." She said, "I wanted a finding, a real one, on the public record that says what happened to me was wrong, and that what your company did before that was wrong, and that both of those things are now part of a record that cannot be quietly settled into silence. That is worth more to me than anything your attorneys could have offered me to make this go away." She said, $1 was enough to get that. So that's what I asked for. The courtroom was silent. I have presided over a great many hearings in 40 years. I have heard a great many explanations for why someone did what they did. I do not think I have heard one as clear or as quietly devastating as the one Margaret Chen just gave a man worth $2 billion in front of his own attorneys. I issued my ruling that morning. Wrongful termination, found in Margaret's favor, on the record, with full findings of fact regarding the retaliation. Whistleblower protection violation, found in her favor, with specific reference to the prior incident she had uncovered, which I ordered referred in full to the relevant federal regulatory authority for independent investigation, not as a request, as an order from this bench, with the full documentary record attached. Damages, $1, exactly as requested. I want to tell you what I said before I struck the gavel, because I do not often editorialize from the bench, but this case asked for it. I said, "Ms. Chen, the law allows you to ask for what you believe is owed to you, and you have asked for less than almost anyone who has ever stood in this courtroom. I want the record to show that this court understands exactly what you actually asked for, because it was not $1. You asked for the truth to exist somewhere that could not be bought back into silence. The law granted you that. I hope it was worth what it cost you. Margaret Chen did not cry. She nodded once, the same composed nod she had used throughout the hearing. It was the gallery that reacted. I do not allow applause in my courtroom, and the gallery, to their credit, did not applaud. But they stood, quietly, almost involuntarily, the way a room stands for something it does not have words for yet. People who had come that morning for entirely unrelated cases, a parking dispute, a lease disagreement, someone waiting for a small claims matter that had nothing to do with pharmaceuticals or billionaires, stood up out of their seats because they had just watched something happen that they understood, immediately and completely, even without anyone explaining it to them. Victor Sandoval remained standing at the front of the courtroom for a long moment after I struck the gavel. Then he turned to Margaret again. He said, "I am going to make sure the regulatory referral has everything it needs from us, voluntarily, before they ask for it." Margaret said, "I'd appreciate that." That was the entire exchange. I have thought about Margaret Chen's dollar many times since that morning. I think about what it means to want something other than money when money is the thing every system is built to offer you. Lawyers exist to maximize financial recovery. Settlements exist to make problems disappear quietly and profitably for everyone involved, including the person who was wronged. Every incentive in the legal system, every habit of practice, every assumption that David Osei's larger competitor firms had made when they declined this case, all of it pointed toward money as the obvious objective. Margaret Chen looked at all of that and decided the obvious objective was the wrong one. She understood something that I think most people, most of the time, do not fully internalize, that a settlement is silence with a price tag attached, that the 3 patients from 18 months earlier had each, presumably, received compensation and had also, presumably, signed away their right to ever speak about what happened to them publicly. Their silence had been purchased, legally, cleanly, with paperwork that any attorney would call standard practice. Margaret refused to let her own silence be purchased. She built 412 pages, not to maximize a number, but to maximize a fact, the fact of what happened, documented so thoroughly that it could not be argued away, requested in a form so small that no one could claim she had done it for the money, delivered in a forum so public that it could never again be quietly resolved into a confidentiality agreement. $1 was not a strange amount. It was the only amount that proved her real motive beyond any possible dispute. I think about what would have happened if she had asked for more. If she had asked for the kind of damages her case could plausibly have supported, and it could have supported a great deal more than $1, Richard Voss would have negotiated. There would have been a settlement conference. There would have been a confidentiality clause, almost certainly, because that is how these things resolve when real money is on the table and a company the size of Victor Sandoval's wants the matter closed quietly. The prior incident might never have surfaced in open court the way it did that morning. It might have surfaced eventually in some other context, through some other whistleblower, with less patience or less restraint. Or it might not have surfaced at all. Margaret Chen's $1 made silence impossible. That was the entire design. Now I need to ask you something before you finish watching this. If you found evidence like this, something your employer was hiding, something that could change your life financially if you sold it the right way, what would you have done? Tell me honestly in the comments. I am not asking what you think the right answer is. I am asking what you actually believe you would do, because I think most people, if they are honest, are not certain. I think Margaret Chen's choice is remarkable, precisely because so few of us are confident we would make it. Share this video with someone who needs to hear that the right thing and the profitable thing are not always the same thing, and that choosing the right thing sometimes requires asking for almost nothing in order to get everything that actually matters. Subscribe to this channel. I have 40 years of these mornings, and Margaret Chen's is one I will not forget. She sued her billionaire boss for $1. She won every cent of it. And the courtroom stood up because for one quiet morning, everyone in that room understood that some things are worth infinitely more than what they cost.